What section is that you're using for the detention?
I don't know, I'm sure you can look it up on your phone.
No, if you're going to detain somebody, you need to know what you're detaining them with. PC brand.
In this episode, an auditor enters a public job centre acting lawfully, yet police intervention follows without clear evidence or a defined offence. Officers rely on allegation rather than assessment, moving straight into enforcement mode. One officer asserts authority without articulating legal powers, while available evidence is ignored in favour of convenience. As the encounter develops, necessity is claimed but never established, proportionality is misunderstood, and decision-making shortcuts replace proper procedure. This case exposes how quickly policing standards unravel when assumption overrides law, and how easily lawful conduct becomes a target once process is abandoned.
You got any idea on you at all, sir?
No, sir.
Okay. Have you got any bank cards or anything that I can confirm that name with?
Not on me, no.
Okay. Are you going to be known to us in police systems?
Yes.
Lovely.
Yes, this isn't the first time that I've been unlawfully, arrested actually. I've been unlawfully arrested twice now. Sued both times. Won both times. This will be number 3. I could have not given you my details and just taken the unlawful arrest, but...
Here, the officer asserts that the conduct is probably Section 4 public order, despite admitting no review of footage or independent evidence. Section 4 requires threatening, abusive or insulting words or behaviour that cause harassment, alarm or distress, assessed objectively. Crucially, officers must form reasonable suspicion based on evidence, not numerical advantage of complainants. 3 allegations do not equal proof, and law does not operate on a majority vote. This moment shows a procedural failure, treating accusation as confirmation. That approach directly conflicts with both PACE and the national decision model, which requires officers to test credibility, context, and proportionality before asserting criminal liability.
Point across.
Okay, go on. You got 3. Yeah, you got 3. You got 3 witnesses.
Witnesses who have all told me that you've said things to them which aren't very nice, which is a public order offence. Okay.
It's not though, is it?
It is. Section 4 of public order, yes. If it's caused them harassment, alarm, or distress, yes, it is. Okay. And I think you know that as well, don't you? Which is why I've requested the details.
It's got to be threatening, abusive, isn't it? Language.
Or visible representation.
Or visible representation, yeah.
So
And
abusive, I would argue what you've said is abusive.
is it? How do you know? And what have they told you that I've said?
Like I say, if it does go that far, you can discuss that in interview.
Okay.
If they make a formal complaint, you'll be invited into a voluntary.
This is a critical failure. An officer explicitly states they are detaining an individual while being unable to identify the legal power authorizing that detention. UK law is unambiguous. Any detention must be lawful, specific, and clearly communicated. Detention without knowing the statutory basis is not a technical oversight, it is unlawful restraint. PACE, common law or public order powers cannot be applied retroactively once challenged. The moment an officer cannot articulate the power, the detention collapses. This exchange alone would be sufficient to undermine the legality of everything that follows, including the retention of personal data.
Am I detained at this point, by the way?
On suspicion of the offence, yes. Whilst I ascertain your name and address, yes, you are.
Okay. And what section is that you're using for the detention?
I don't know. I'm sure you can look it up on your phone.
No, if you're going to detain somebody, you need to know what you're detaining them with. PC brand. I'll ask you again, what are you detaining me under? What section are you using to detain me? I've given you my details.
Just bear with me a minute.
No, I'll keep talking. You don't have to listen if you don't want to. You got me on there?
I think we have, yeah.
Yeah, there we go.
Just confirm where you were born for me.
You've got me on there, Constable. I've given you all my details. They all match up with the system that you've got on there, and I said I would be known to you. You don't need...
The officer now pivots to breach of the peace, a common law power frequently misunderstood. Breach of the peace requires an imminent risk of violence or harm, not past allegations, not verbal disputes, and not administrative convenience. The individual is seated, compliant, and non-threatening. No imminent violence is identified. This misuse is significant because breach of the peace is preventative, not punitive. When officers stretch it beyond its lawful scope, it becomes a tool of removal rather than protection. Courts consistently scrutinize such uses, and when the threat is speculative rather than immediate, the power fails.
Leave premises now. We'll
Right.
go outside. Presumably you've got a vehicle because I can see you've got a motorcycle.
And the purpose for asking me to leave again?
Prevent a breach of the peace.
And what breach of the peace do you suspect would happen?
Based on the fact you've been abusive to the staff here, I don't want anything to.
It has to be. Yeah, a breach of the peace constitutes physical threats or actual violence to a person or their property in their
So being
presence.
abusive to somebody could also constitute.
I've been sat here peacefully, Constable. They're the one that surrounded me and
To
attacked
prevent a
me.
breach of the peace. Okay, so what I'm going to ask now is for you to leave the premises, please.
And if I don't,
Okay, I need you to leave the premises.
okay, and I'm asking what happens if I don't,
I need you to leave the premises, or we'll have to forcibly remove you from the premises
using what power?
to prevent a breach of the peace.
And that's
Public Order Act.
not a public order act, is it?
It is.
It's not.
Okay.
That's common
Is there
law.
anything
Oh
I can
wait,
say or
actually,
do
no,
to make
maybe
you reasonably comply with my request?
maybe it has been in the new public order act, actually,
So
isn't
I'm
it?
going to give you one more opportunity, please, to leave the premises. Or we'll
Right.
remove you.
Okay, under threat of violence, I will move. Under threat of arrest, I give you my.
This exchange exposes the core procedural flaw. The officer acknowledges that readily available video evidence was not reviewed before exercising police powers, citing proportionality and time. The national decision model does not permit shortcuts where evidence is immediately accessible and decisive. Proportionality cuts both ways. The intrusion into personal liberty must be justified against the effort required to verify facts. Choosing not to review evidence while still escalating enforcement reverses lawful policing logic. At this point, the issue is no longer disagreement, it is process failure. When decisions are made first and evidence is examined later, legality is already compromised.
Aware that we have a national decision-making model.
Yes.
Yep. So we go into a location, as you say, we assess what we've got in front of us. Yes, you may be sat down. Yes, you may not be being abusive or whatnot at the time. If I have an allegation from a member of the public stating that you've done X, Y, Z, I have to take that seriously. Don't have a duty bound to investigate it. Like I'll be doing with the same allegations that you've made.
Yeah.
However, hindsight's a wonderful thing, isn't it? If I'm not there, I've not seen what's happened, I can't
Yeah.
say for sure. At the moment, I've got 3 against 1 telling me one thing, you're telling me another thing. So I've got to go off what I've got.
I think it's completely wrong that instead of when the evidence is right there available to you, instead of checking the evidence, you've gone straight to invading my right to privacy. Because you may say
Sorry, what's this right to privacy?
my details
Okay.
that you've taken stolen from me today.
Okay.
I will say
We've ascertained.
stolen from me. I will say. Okay. Under fear of arrest, I've given them that's stealing in my eyes.
Yeah.
Okay. So I will say stolen. My details that you've stolen from me today, when the evidence was there, you say it's not proportionate because it takes too much time, right? I say my right to privacy outweighs your ability to move on to the next job because they've made false allegations. That's my view, and the courts will see what the court's view on that is, because I will be suing you for this. I will be taking it to court.
No worries.
Again, twice I've won already, and you will be the third.
Okay.
And you have messed up today, taking my details.
You're free to make a complaint, make a lawsuit, whatever it is you feel like you need to
I will.
do. As I've already
I take
explained.
my freedom seriously,
As
Constable.
I've already explained, I've had reasonable suspicion to ascertain the details and the circumstances.
You
Unfortunately,
should have reviewed all the evidence and all the facts.
Okay.
You've made a decision based on one half of a coin,
like
one
I
side
say-
of a coin.
Like I say,
You have not
reviewed
reviewed the
I'm going
evidence.
to go back in there